So in this video, I want to talk about a Supreme Court case that will impact the Second Amendment, but everyone is overlooking it. This case is the American Hospital Association v. Becerra case, and it may do away with a lot of the ATF Second Amendment infringements that we've been seeing. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank one of the main sponsors of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn these skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below. And thank you again, SDI, for sponsoring this video. So I guess in the intro, in this video, I want to talk about a case called the American Hospital Association v. Becerra case that has been argued before the Supreme Court and is set to be decided this month. This is an important case that many in the Second Amendment community are overlooking, mainly because there is a different case currently directly challenging and dealing with the Second Amendment that the Supreme Court will be ruling on this month, and that is the New York State Rifle and Pistol Association v. Bruin concealed carry case. However, the American Hospital case is another important case because the Supreme Court decision here will likely restrict future ATF actions which attack our rights to keep and bear arms, because the ATF has been a rogue agency that has done multiple actions in violations of our right to keep and bear arms by interpretatory processes, by arbitrarily changing definitions, and pretty much just going rogue and regulating things however they want. And this case that's being overlooked could do a lot to actually stop those actions from the ATF. Now, some quick background on this case. The American Hospital case is a challenge to a decision by the U.S. Court of Appeals in the District of Columbia, the circuit court there, which upheld the U.S. Department of Health and Human Services final rule which reduced the Medicare reimbursements for prescription drugs. While this case has significant ramifications on many hospitals that participate in the program that's being challenged in the case, the implications of the opinion that will be released will be much broader and will have larger impacts, including on the ATF's actions against things like I mentioned, bump stocks, frames and receivers, pistol braces, and more. At its core, the American Hospital case is not just about payments for prescription drugs, but it goes much further than that. It is a vehicle for the Supreme Court to consider the vitality and scope of the Chevron deference doctrine, and it's a way for them to look at that once again. Now, if you're not aware of what Chevron deference refers to or the doctrine of Chevron deference is a term coined after the landmark case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, there are other canons of regulatory interpretation that a court could use. For example, the rule of lenity indicates that when dealing with criminal statutory interpretations, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency like the ATF. Under the rule of lenity, a court should err on the side of the people who would be subject to those criminal penalties instead of the agency like the ATF. In American Hospital, the petitioner argued to the Supreme Court that the court should approach Chevron deference in a way that the court must exhaust its statutory interpretation toolkit, taking into consideration the language, structure, operation, and provenance of a statute before deferring to an agency's interpretation of a statute under Chevron. So in summary, the main thrust of the argument made in this case to the Supreme Court is that the Supreme Court should find that courts must use all other canons of regulatory interpretation before they apply Chevron deference and therefore defer to an agency's interpretation of a statute. Now, you may be asking yourself at this point, why does this matter for the Second Amendment context? This matters because of all the pesky ATF actions that we have seen pop up over the last few years. The ATF has consistently engaged in interpreting ambiguous terms in their eyes. They say a lot of these terms in the things like the GCA and the NFA are ambiguous, and they say that they can interpret it however they want under Chevron deference to find the true rational, reasonable interpretation of those terms. So for example, when you look at the ATF's actions against bump stocks, for many years the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, all of a sudden, the ATF decided to arbitrarily change the regulatory definition and interpretation of machine gun so that bump stocks would be considered to actually be machine guns. Under this new interpretation, the ATF created a new rule defining bump stocks as actual machine guns, and therefore made their possession illegal and subjected citizens to 10 years in prison and or a fine of $250,000 if these people decided to either not destroy them or they failed to destroy them or to surrender the devices over to law enforcement agencies. This interpretation by the ATF is being challenged at the Supreme Court level in two other very important cases. One of those cases is Apashian v. Garland, and the other is a GOA case, and both of those deal with bump stocks. In the Apashian case, one of the main arguments is that the court should not defer to the ATF's interpretation of machine gun, especially when such deference would result in severe criminal penalties. Instead, if a term like machine gun is found to be ambiguous by a court, then the court should use the rule of lenity, not defer to the agency's interpretation under Chevron. Now, Apashian currently has been scheduled and rescheduled for Supreme Court conference multiple times. At this point, it's been somewhere around 20 plus times that it's been scheduled for conference and then moved. What this could indicate is that Supreme Court is hesitant to take up this Chevron issue, specifically in regards to the ATF, or it could be that they will take up this issue, this bump stock ATF interpretation issue, and just the arbitrary reinterpretations of terms under the GCA and NFA by the ATF. They could take up that issue once they rule in the American Hospital case. So this could be one of those things where, although this case does not directly deal with the Second Amendment context, it will have significant ramifications on other cases that are currently going. Depending on how the Supreme Court rules on Chevron, the American Hospital case will be impacted, and the ATF's actions on bump stocks, their new rules on frames and receivers, their new rule on banning pistol braces, their actions in treating things like the rare breed FRT-15 trigger as an actual machine gun, and so many more things could be impacted by this decision. It's highly unlikely, in my opinion, that the Supreme Court would completely strike down Chevrons or get rid of it. If you've listened to the oral arguments for this case, the tone of the justices is nowhere near that drastic. I don't think they're going to go anywhere near that far with this decision. But what can happen is a softening of the use of Chevron deference. Instead, what the court may do, in their opinion, is say that these agencies like the ATF cannot rely on Chevron deference for their actions like they have in the past. They may say that if an agency says something is ambiguous, the court must look at the ambiguity, apply all other canons of interpretation first, like the rule of lenity, before they use Chevron. That change in interpretation process would drastically remove the protection that the ATF has used to this point. What could happen is the ATF would no longer be able to arbitrarily reinterpret statutes to fit their agenda, their gun control agenda, and then claim protection under Chevron deference. Instead, the courts would be forced to apply things like the rule of lenity instead of Chevron, and that would lead to drastic change and weaken the ATF's current actions. So although this case does not deal directly with the Second Amendment, it will address a concept that to this point has been used by the ATF to attack our rights to keep and bear arms. Because of that, I will be keeping my eyes on the American Hospital v. Becerra case and be waiting for this decision, which will come by the end of the Supreme Court's term. It's already been heard, it's been argued, and now we're just waiting on the decision. And this would be a big win for the 2A community, depending on how they deal with Chevron deference, because again, this could go a long way to reining in the ATF. So that's just a quick rundown of an important Supreme Court case that is being overlooked by the 2A community. If you have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget to stay with Built Bar Arms Scholars and the station will maintain Bar Arms Scholars.